You might want to stand and stretch for a second here. If you would like to do so, you are so afforded the opportunity. One of the members of the board didn't want to pose a question. Chair will permit. Supervisor Yaroslavski.
Thank you, Mr. Chairman. The gentleman who spoke in the first gentleman on that last panel, I don't recall his name. He's sitting there. I'd like to ask him to come back. Yes, sir. Could you come back up here? I just have a couple of questions I wanted to ask. Thank you. Just restate your name so I know it.
My name's Jordan Porter.
And you represent?
Matrix Oil Corporation
Okay.
and Clayton Williams Energy, Inc.
Okay. Do you believe that the oil company had a responsibility, or the city of Whittier, or both, had a responsibility to seek the approval of the open space district and this Board of Supervisors before commencing this deal or entering into this deal?
I think there's two parts to the answer to that question. The first answer is that the legislation that created or enabled the creation of the Prop A district specifically proscribed those districts' ability to interfere with land use control of other cities or districts within the larger regional district unless you had a written authorization and consent from both the
Okay.
Board of Directors of the district.
Sir,
Well,
you're not answering my question. Do you believe, just answer yes or no, do you believe, if you can't answer yes or no, that your company had a responsibility at some point in this process to seek the approval of this open space district for what you wanted to do?
No, because the city of Whittier and the district has maintained this throughout. It's the city of Whittier's responsibility to do that. And furthermore, before the issue went out to bid, before it was proposed, before Whittier solicited requests for proposal on August 26, 2008, in the months before that, pursuant to the project agreement, which required district consent or district review and approval of proposed leases, and by the project agreement, that means the district staff, not the County Board of Supervisors, acting as its Board of Directors. And the months before, August 26, 2008, when Whittier put this out to bid, they circulated the language of the lease to the district staff, to County Council. County Council had input into that lease and approved the lease and directed Whittier to proceed with its solicitation.
So your argument is that the staff acting on behalf of the open space district had the authority to approve the open space district's consent, to grant the open space district's consent for the oil drilling? That the Board of Directors of the open space district, namely the five of us, are just a potted plant? Is that what you?
That's exactly what the project agreement directs Whittier to do, and in fact, and indeed, with other communications between Whittier and the open space district, with other issues surrounding Whittier's Prop A property, that is exactly what has happened in the past.
Okay. Last question, Mr. Chairman, and I know you're trying to keep this moving and you're doing a good job, and I'm going to try to help you out, but the last question I want to ask you is there have been a number of occasions when both the city of Whittier and your oil company, Matrix, have argued that this district, the open space district, will lose its right to review the lease as early as November 8th, 2013, and no later than June 20th, 2015. And those representations have been made relatively recently.
Yes.
How do you reconcile your company's statements on that front with what you just said?
Well,
how would we, one last question, then you can have the floor. How would we review this project absent a hearing like this?
Well, okay, to begin with, your first question.
Go ahead.
Under the project agreement, the contracted right to review and approve proposed and existing leases exists for a period of 20 years from the date of execution. That project agreement was executed November 9th, 1993. The 20-year contractual right, which is the only right that the district obtained through this litigation, expires November 8th, 2013. Secondly, the contract itself, the project agreement between the district and Whittier, expires by its own terms on June 30th, 2015. County Council may not have mentioned the fact that the injunction stopping the project ends on June 30th, 2015.
Yeah. My question to you was, how would the Open Space District have reviewed your project absent a hearing such as this? Okay?
Well, what the district had suggested in its court filings was that Whittier make a written request to the Open Space District to make that, to have that review. And for more than 4 years, until the district sued Whittier 1 year ago, Whittier had repeatedly made those requests, and the district had refused to take it up. The record is replete with requests for the district to review this.
We are taking it up now.
Well,
where is the city of Whittier?
Well, the problem is that there's no request for the district to take it up right now, and there's a jurisdictional problem.
So you're saying that we have a right to review it, and we better do it before November 8th, but we can only do it if the city of Whittier makes a request to be heard on it, and if they don't make a request to be heard on it, then we have no ability to opine on this and to review it and to conduct a hearing of this type. I find it bizarre that basically what you're arguing and what the city of Whittier is arguing, and this is, the court cases are not over, as you well know. What you're arguing is there's something in what you're saying that suggests that Prop A only lasts for 20 years. The funding revenues only may last for 20 years. The open space commitment that was made to the people in exchange for their vote to approve this revenue stream was that the open space would be in perpetuity. That in perpetuity, please, that in perpetuity language does not get cut off in 2015 or 2075 or in 2115. Perpetuity means in perpetuity, and the notion that some body, some business can come in and cut a deal around the open space districts, and cut some kind of a real estate deal or business deal, and thus frustrate the intent of the proposition, both Proposition A of 92 and 96, stands logic on its head. So, I mean, I've read everything you've sent, or your representatives have sent. I've read everything, the 20-page stuff I got here this morning, which we've read. I've read it all. And what it really comes down to is you don't think you need to comply with the rules as established by the proposition. And you're even inconsistent on the question of whether we have a right to have this hearing. I mean, you're saying that we invented this hearing, we created it out of whole cloth, my words, not yours, that this has no force and effect on anybody, yet on the other side, with the other side of your mouths, you're saying you have until November 8th to opine on this thing, or you lose your right to do it, which we don't agree with, by the way. We don't think it cuts off at November 8th, but let's stipulate that you're right on that one. Here we are on October 28th. And you're saying we have no right to do this. Anyway, thank you for giving me the time.
Well, hold on.